Okay, so last night I was waiting for a video to process because sometimes my editor has decided if there's too much video in the video, then it's going to be a bigger issue for the editor. So then I got to send it to some software to compress it to where it doesn't absolutely mess it up. And then it's another whole process after another. Anyway, while that was going on, I was flipping through some comments and I came across this one from Officer Taterhater. Now, I have a question, Officer Taterhater. Are you the same Officer Taterhater from Rick Gore's channel, Good Luck America? If so, I see you over there quite frequent. Well, I used to. I'm not. Since he went to X, I'm not on there as often as I used to be, but I mean, I'm still there from time to time. And the name seemed familiar because it's funny that he used to do a thing bashing the Officer Tatum, and then we have Officer Taterhater show up. I'm just saying. Anyway, the comment was to the latest one on my Huntsville, Alabama video was higher standards, laughing my ass off. Until you put these perps in general population, this will continue. Look up the Rankin County Goon Squad. That one will make you sick. And I thought, wow, if it will make me sick, Officer Taterhater, I feel like I need to look that one up. And let's just say, this comment did not disappoint. So, I could only go back about 2 years. Once you get earlier than 2023, the information is really lacking. And videos are, this content isn't available, and when you click on an article, this link is no longer available. So when you start getting like 2023, I think is as far back as I could go. When you get to like 2020 and 2019, because this shit has been going on for a while, that link doesn't exist. The video is gone. So anyway, I found what I can find, and let's see what I found. We're going to go back 2 years.
Well, multiple human rights organizations came together to protest against the Rankin County Sheriff's Department. Black empowerment and local chapters of the NAACP gathered at the Rankin County Justice Court to express their frustrations toward the Rankin County Sheriff's Department after officers allegedly beat and tortured Michael Jenkins and Eddie Parker. Now, the Mississippi Bureau of Investigations says the two men were arrested during a drug raid at a Rankin County home on January 24th. Jenkins was hospitalized after being shot by officers during the arrest. Attorneys say it was a racially motivated attack and are demanding the officers involved be tried and arrested, as well as body cam footage.
What needs to happen is that good police need to be separated from renegades, because these people have gotten comfortable. Because the one thing I can guarantee you, it's not the first time that this has happened. This is the first time that they're...
How many times have I said this? This is not a one of. How many times have I said it? Like Robert Brooks. Only because he died is all this shit coming to light. It's never a one of. This shit has been going on for a hot minute.
Being called into account for it. So we want them to know that we're here for justice, and we are not going away. And we're going to stay here until justice gets done in this case and in other cases where brutality has occurred at the hands of the Rankin County Sheriff's Department.
Our young black men are being held or revealed as public enemy number one. And for me, I have a vested interest in that because I'm raising two sons that I'm in fear for their lives because they go out the house every day. And I teach them, you don't run, you don't resist, you answer the question, yes sir, no sir, you live to tell your story.
The U.S. Department of Justice has opened a civil rights investigation. The Mississippi Bureau of Investigations has not released the police body camera footage and are still investigating the case. Well, multiple...
Stop. Okay, so these are the ones we're going to follow because trust and believe there's more than this. These are the ones we're going to follow through this video. And then we have this from a year ago.
And new developments tonight in the investigation into the alleged beatings of two men by Rankin County deputies. Attorneys for the men have filed charges with the Department of Justice that go beyond human rights violations. Rosalind Anderson has details.
This is one of the nastiest police cases ever, and we won't let it die.
Black Lawyers for Justice League counsel Malik Shabazz reveals startling information in the plea to the U.S. Department of Justice for federal charges against 6 Rankin County deputies. In January, 32-year-old Michael Jenkins and 35-year-old Eddie Parker say they were beaten, waterboarded, tasered, subjected to racial slurs, and sexually violated.
In the course of it, that they attempted to use a sexual device, or what they call a dildo, on the 2 men, and they were almost successful. It sounds shocking, but it's true.
The deputies reportedly entered the residence without a warrant. The attorney is now identifying some of them.
These 6 deputies, which include Hunter Elbert, same deputy involved in the Damian Cameron death, which includes Christian Dedman and Brett McAlpine.
Attorneys plan to file a $400 million lawsuit against the Sheriff's Department and is calling for Sheriff Brian Bailey's firing. A town hall meeting with the NAACP is planned for June 10th at Pilgrim Rest MB Church in...
All right, I'm not sure why it just stops like that. So anyway, I found an article, and let's see if this tells us anything we don't already know. And this is from February 21st, 2025. Former Mississippi Sheriff's deputy describes rampant violence by the Goon Squad. From a prison cell, a former deputy recounted how illegal searches and brutal beatings went on for years, helping win drug convictions in his suburban county. In a series of interviews from prison, a former Mississippi Sheriff's deputy described for the first time how he and others in his department regularly entered homes without warrants, beat people to get information, and illegally seized evidence to help convict people of drug crimes. His statements corroborate many aspects of an investigation by the New York Times and Mississippi Today that uncovered a 2-decade reign of terror by Rankin County Sheriff's deputies, including those who called themselves the Goon Squad. They also shed new light on the deputies' tactics and the scope of their violent and illegal behavior. The former deputy, Christian Dedman, who once led the department's narcotics divisions, told Mississippi Today in emails and phone calls that drug raids occurred in suburban Rankin County outside Jackson almost every week for years. He said deputies regularly brutalized and humiliated suspects to get them to share information during the raids. And he said they often seized evidence without a legally required warrant, raising questions about possible wrongful convictions in hundreds of narcotics cases stemming from the raids. For some raids, he said the deputies would falsely describe emergency circumstances that gave them cover for searching without a warrant. For others, they would falsely claim that evidence was in plain sight. Now, exigent circumstances is where they're leading with this. Exigency is the exception to the warrant requirement. But exigency used to be narrow scope, where you are legally allowed to be as a law enforcement officer. You can see in a house that you're heading to, and you can see they're destroying evidence, they're beating someone, they've got a gun in their point. Anything that creates a exigency for you to be in there, that is the exception to the warrant. However, cops and unions have stretched the exigency, and anymore they don't even have to prove what their exigent circumstances was. They can just say, well, exigent circumstances, officer safety, I had to do this, I had to do that. And people hear that and they're like, well, hell, officer safety and exigent circumstances. Most people have no clue what that is. And they're like, well, the cops must have been right because they're cops, right? Incorrect. He said deputies were entering homes without warrants so often that in 2022, a senior detective warned him that prosecutors in the district attorney's office had noticed and had demanded they stop. Senior detective warned him that prosecutors in the district attorney's office had noticed some shit. The violent raids continued until at least 2023, when Dedman and 5 other officers barged into a home without a warrant and then beat and tortured 2 black men, Eddie Parker and Michael Jenkins. One of the deputies shoved a gun in Jenkins' mouth and shot him, shattering his jaw and leading to a federal investigation. Dedman and the other officers pled guilty last year and were sentenced to prison. I lived a lie for long enough, said Dedman, who is serving a 40-year sentence. I owe the truth to my daughter, to every person in Rankin County, and to law enforcement as a whole. Well, what you owed was, at the time of the shit, to do something about it and not go along with it for so long that you're in prison for serving a 40-year sentence. Likely not. Anyway, the good cops wait till there's a federal lawsuit to do anything about it. District Attorney Bubba Bramlett has declined to share details on how his office has approached a review of drug cases for possible wrongful convictions, but reporters found dozens of pending drug indictments that were dismissed, some of them citing the fact that deputies associated with the Goon Squad were unavailable as witnesses. According to local defense lawyers, the district attorney's office is now reviewing cases where defendants pleaded guilty, ruling out a vast majority of drug cases involving the deputies. Dedman estimates that there were hundreds of home search break-ins without warrants in recent years. Also, riddle me this. You're sitting on your couch and somebody comes and kicks your door in and you are legally allowed to have a firearm and you double tap and shoot and kill them. What happens then? You didn't know who they were. They kicked your door in. And it was a cop. Who do you think is going to win that battle? We'd have to see that one play out now, wouldn't we? In their guilty plea, 6 law enforcement officers, 5 of them deputies, admitted they had broken into a house without a warrant and brutalized Parker and Jenkins. Prosecutors described how the officers tried to conceal their actions by placing a gun at the crime scene, destroying surveillance footage, and using drugs from another bus to falsely incriminate the men they attacked. Which is, again, trust none of them. Verify everything. Never, if you get stopped on a traffic stop, don't let them in your car. No, you do not know what they're going to put in that car. Don't, unless you got some cameras in there that's running and capturing everything. Do not let them in your cars. Do not let them in your house. Dedman said the actions officers took that night were extreme. He said that a majority of drug raids involved suspects who were buying or selling drugs, but that violence and a willingness to bend the rules to enter homes were common. Of course they were. Goon Squad. The most frequent approach was a knock and talk, where deputies would tell those inside that they would not be arrested or that it would be easier for them if they cooperated, he said. Now, knock and talk. Yes. Police, would you come talk to us for a minute? Don't do it. Don't fall for it. Don't open the door. Your answer to that should be come back with a warrant. Because if they do a knock and talk and they knock and you open the door and you walk out there and you talk and they decide you're not going back in, you're not going back in. Or if you open up that door and they stick their foot in there, trust and believe, if you shut that door, they're going to get you for assault and battery, and then they're going to go after you and they're going to take you to the ground and you're going to go with them. It's never going to work out in your favor. Don't open the door. That might be a lie because they might be arrested or charged, he wrote. It's not illegal, and it's often used as a tactic to lie to violators to get them to cooperate and make your job easier. Dedman said the deputies would also carry out a buy bust, where an informant would enter a home, buy drugs, and then we would kick the door in upon them leaving. He said deputies knew that after securing a home, they should seek a search warrant from a judge and then wait at the property until they were cleared to gather evidence. That rarely happened, he said. Absolutely. The problem is, most judges, they don't care. They'll sign off on the warrant. They're just to get, it is Friday night at 10 o'clock, and the judge has got to answer your shit. Just, yes, here's a warrant, whatever. Instead, he said, deputies would immediately start their search and in their subsequent reports cite exigent circumstances. That's what I was talking about earlier. Which U.S. Supreme Court has ruled allow a warrantless search. The court has held that officers do not need a warrant if they believe an informant is in danger, if the suspect is about to destroy evidence, or if they face similar emergencies. Now, the problem is, all they have to do is say that. They don't have to prove it. There should be documented proof of what you did, and, I don't know, more than you say, and that's what happened, which wouldn't matter because they're all going to lie for each other. Exigency and being the exception to the warrant is, it sounds good on paper, but it really doesn't mean anything. Eve Brensyke Primus, a University of Michigan Law School professor and director of The Public Defender Training Institute said if the evidence seized in a warrantless drug raid is critical to a case, that would be a serious Fourth Amendment violation that would result in reversal on appeal. Well, that would depend now, wouldn't it? There's a lot of depends there. Depends on who you believe. The Fourth Amendment is designed to prevent arbitrary and harassing police searches through a warrant requirement, she said. We want police to go to a magistrate or a judge to get a warrant before they search a home because homes are so private, and we want a judicial check on the police officer determination of probable cause beforehand. Also, a warrant is supposed to describe the persons and places to be searched and the evidence to be seized. So, let's say they're looking for a 2012 Ford Expedition. Okay, a 2012 Ford Expedition is huge. So you can only look somewhere where what you're looking for could be, right? So that would never take them inside the house because who's going to put an Expedition in the house? Stop. Here's how it works. In order to get into your house and to get into every single nook and cranny in that house, the basis of the search is the Expedition, but then on the supplement to it, they're like, yeah, 2012 Ford Expedition, and it's blue, and here's the tag. And also, we want the keys for it. We want the title for it. We want the air freshener that was in the window. We saw a key that might go to something that we're looking for. So now they're looking for the Expedition, but they can also look anywhere a title can be, a registration could be, a key could be, that bag of something that they thought contained something that was anything. The Ford Expedition was the basis of the search, but now they're looking for something as small as a key. How small of areas can a key be in? See where I'm going with this? This is exactly how they get into your house and they toss it and they go through every single nook and cranny. And then you say, well, no, you can't do that. You were looking for an Expedition. Yes, finish reading the warrant. All the way down to and including the key for it. And they can look anywhere a key can be. That's how that works. Previous reporting by the Times and Mississippi Today documented 17 cases where victims and witnesses alleged misconduct by the Rankin County deputies, often involving the same men convicted in the Parker and Jenkins case. Some described being beaten or choked or having guns shoved in their mouths until they confessed. One man said deputies shoved a stick down his throat until he vomited. Another said deputies used a blowtorch to melt metal onto his skin. This is the depravity that is running amok and has been apparently for 2 decades in Rankin, Mississippi? This is, oh my God, I hate to keep saying it. You can't make this up. This is law enforcement. Dedman said he and some other deputies learned their techniques from Brett McAlpin, a longtime narcotics investigator in the department, whom federal prosecutors described as molding officers into the goons they became. He said McAlpin handled writing up many of their raid reports and taught deputies how to use violence and humiliation to get information from drug crime suspects. The goal was to create as much chaos as possible to prevent such behavior in Rankin County, Dedman said. That's how they solved cases and prevented drugs from being sold in the community. He said he knew the violence was wrong, but he idolized McAlpin, who is now serving 27 years in the Parker and Jenkins case. You idolize somebody that you know is not only breaking the law, but just has no basic human dignity about them. And you idolize this person that you know everything they're doing is wrong. Not only on a law enforcement level, but on a basic human dignity level. And that's where we're at with that one. He was the first person I ever saw destroy people's property out of his own hatred for the way they lived, Dedman wrote in an email. Sickly enough, I grew to believe that it was the right thing to do. Did you? That was the right thing to do? He said it was McAlpin who passed on a warning from a prosecutor in the district attorney's office demanding that the warrantless entries had to stop. Dedman said the warning was specifically aimed at him, according to what McAlpin told him. He said to me that times are changing in the DA's office, Dedman recalled. So it sounds to me like maybe the DA had been letting him get away with it for a minute, and the DA started getting some whispers in his ear, and then the special agent and the DA had some chat, and the DA's like, Y'all got to rein this shit in. We got to start holding some people accountable. In a written statement, Jason Dare and the lawyer for the Sheriff's Department and Dedman's remarks insinuated that investigators with the Rankin County Sheriff's Department do not procure search warrants for residential searches. Such a generalized accusation against our investigators is false, defamatory, and easily disproven through readily available public records. Really? Because we would like to see them public records, because as far as any camera footage, they're like, we got to think about if we're going to release it or not. We haven't decided, but we'll let you know when we decide. In 2023, while investigating allegations against the Goon Squad, reporters for Mississippi Today and The Times sought copies of warrants related to 9 raids by the unit. The department did not provide the warrants and referred reporters to the district attorney's office, who declined to release any documentation. But of course, the comment to the comment is what? No comment. Dare said Dedman's statements to Mississippi Today show the former narcotics investigator admits that he knew right from wrong and admits to falsifying reports to the Sheriff's Department, both of which show that the training and policies of the department taught him how to legally and properly perform his duties. Again, more training. They need more training. No, he said right there, he got the right and correct training that he needed. He just decided that he was a thug in blue line, and that was all he needed to worry about, and he was right for a while. Assuming these statements are accurately reported, they show that Dedman made the choice to commit criminal acts and is incarcerated as a result. Dare said the sheriff has remained committed to the safety and protection of Rankin County citizens. Really? Because where has this sheriff been? Because we know this has been going on, the article said, for 2 decades. Not sure how long this one's been sheriff, but we're going to hear what he has to say in a minute. Last week, the Rankin County Board of Supervisors passed a resolution praising the sheriff for helping save the life of a man who shot himself. We're totally going off script with this one, aren't we? In a 2023 press conference, the sheriff declared that he knew nothing about the violence that his deputies were carrying out. The badge worn by so many has been tarnished by the criminal acts of these few individuals, he said. I've tried to build a reputation here, tried to have a safe county, and they have robbed me of that. How does a sheriff not know what's going on with their deputies? Kind of their whole fucking job. Community relations, right? How is that not? That is an excuse. The not me, don't prosecute me, I didn't know. Bullshit. Dedman said for the sheriff to go on TV and act as if we're just some crazy guys that slip through the cracks is insane, political, and misleading. He said he's seen more than a dozen different officers use excessive force, but I'm the one paying the price for it. The criticism should not detract from some really good law enforcement officers in Rankin County, he said. Any community has to have proactive patrolmen and narcotics officers to be safe. Chrissy Nobile, director of the Mississippi Office of Capital Post-Conviction Counsel, holy shit, and Dedman's statements make it obvious that Rankin drug cases need to be reviewed for possible wrong convictions. These perpetrators controlled the institution that was supposed to investigate these heinous crimes, leaving the victims no recourse, she said. Mercifully, post-conviction allows attorneys to look back when our institutions fail, especially when the failure is of this magnitude. She said her office was willing to carry out the task and would need $400,000 in extra funding from Mississippi legislator to hire an additional investigator and part-time lawyers to review the case. Taxpayers, what's she saying? Get another job. They need more money. Matt Steffi, professor of law at Mississippi College, said prosecutors are expected to seek justice, not just convictions, and have a responsibility to examine possible wrongful convictions, especially when the problems are so acute, profound, and well documented, and they are in the Goon Squad cases, as they are in Goon Squad cases. The Mississippi Attorney General's office, which prosecuted the Goon Squad case with the Justice Department, also has the authority to review the Goon Squad cases. But Marias Lee, its communication director, said the office wasn't examining any cases. Peter Neufeld, co-founder of the nonprofit Innocence Project, said the district attorney has a constitutional and ethical obligation to notify every defendant in every conviction in which these cops played a role in the arrest or prosecution. This has yet to happen, according to lawyers representing some of the defendants. Neufeld said that the U.S. Supreme Court's decision in Brady v. Maryland requires prosecutors to disclose any evidence that might clear a defendant, even if the evidence arises after the person's conviction. I've been involved in multiple situations where prosecutors notify hundreds of convicted defendants where there is misconduct far less egregious than that attributed to the Goon Squad, he said. This is a victim of the Goon Squad. alleged victim of Goon Squad member near property he owns. So yeah, that is a victim. More than a decade ago, Lane Fikes, a Carthage said McAlpin snatched him out of his truck and joined other officers in beating him. They pretty much beat up anybody, he said. That was their M.O., method of operation. The next day I went to the emergency room, he said. I had cracked ribs. Hospital officials urged him to report it, but he said he knew if he did, he would get paybacks from deputies. As far back as I remember, you didn't mess around in Rankin County, he said. If you did, something like this was going to happen. In 2013, a Rankin County grand jury indicted Fikes on charges of selling meth. Fikes, a celebrate recovery leader who has been sober since 2016, said he was addicted to meth at the time, but that he wasn't selling it. Celebrate recovery. Prosecutors kept pressuring him to plead guilty and said he would face 30 years in prison if he didn't take the deal, he said. They get in your head. What did I do? Did they have something on me? He wound up borrowing money to hire his own attorney, Beverly D. Poole, who pushed the prosecutors to share their evidence against her client, including all video and audio recordings. After the prosecutor turned over evidence, Poole told the judge that prosecutors had failed to share everything. When she finally glimpsed the video of the drug buy, Fikes was nowhere to be seen. The judge dismissed the indictments and Fikes walked free. If I had accepted their charges, I would be in prison, he said. How many other people have they done that to? I'm guessing this guy too. Jeremy Travis Page, who had been convicted in Hinds County of selling marijuana and receiving stolen property, said McAlpin pulled him over on August 1st, 2018 and knocked him out with a blow. When he came to, I was being dragged into my house by narcotics officers, he recalled in his complaint to the U.S. District Court. The incident report mentions a traffic stop, but nothing about taking him to his house. Goon Squad officers broke into his home without a warrant after a woman sold drugs to a confidential informant and then claimed he had put her up to it. I got beat down and tortured for hours. I was in handcuffs the whole time. Officer tried to force me to do drug deals off my phone, he said. Instead of setting up deals, he texted family. At one point, Page said McAlpin, a longtime master mason, saw him wearing his grandfather's Masonic ring. He said, "You don't deserve to wear that." And he slapped me in the face real hard, Page said. He about knocked me out. McAlpin swore in a statement that he never hit Page, but extensive injuries can be seen on his face in his jail booking photograph. Page said it was still daylight when the beating by McAlpin and other officers began, and he wasn't booked into jail until 1:30 the next morning. No human being should be treated that way. I was treated that night, he said. An April 2019 grand jury indicted Page for selling meth. I don't see how the grand jurors indicted me when I wasn't even there at the drug sale, he said. There was no evidence, no audio, no nothing. Also, grand jury, that's some secret squirrel shit. You do not get to be in there. It's them. The prosecutors pretty much run the show, and you don't get to know anything about it until they've made a decision. That's how the grand jury works. Less than a year later, he sued the Rankin County Sheriff's Department, McAlpin, and Sheriff Bailey for the beating. Rankin County officials responded to Page that Page wasn't due a dime because qualified immunity protected McAlpin's actions, and the lawsuit was eventually dismissed. Qualified immunity, the premise of qualified immunity was that when law enforcement officers are acting under the color of law and they are doing exactly what they're supposed to be doing, you can't then come back with some frivolous bullshit. Well, I didn't like he put the handcuffs on too tight or this or that. That's what qualified immunity was supposed to be for. Qualified immunity was not supposed to be blanket protection for criminal activities when they know their activities are criminal. And if they're committing criminal activities and they don't know their activities are criminal, we have more problems than that. Qualified immunity is total bullshit, and it needs to go. They can buy a bond, and then when shit hits the fan, they can take the award money out of that bond, and whatever secured that bond, the house, the boat, the car, the dishwasher, the damn ninja, whatever secured that bond can go to finish paying that bond off. Maybe when they have some skin in the game, this shit will turn around. Until then, qualified immunity. While sitting in jail, Page rejected each plea deal until he was told if he didn't accept the offer, he would be prosecuted as a habitual offender and receive a maximum sentence of 80 years in prison, he said. They threatened me with my past. He pled guilty, and the judge sentenced him to 5 years in prison. He is now on parole. He would like to see his case and others like his investigated for possible wrongful convictions. He said, I'm doing time for a charge I didn't commit. We need to see how deep the corruption goes. Well, my guess would be the corruption goes deep. Also, while we're on it, remember the sheriff that said that he didn't know what was going on because, I guess not his job. Let's see what he has to say about it.
All right, David, thanks. Well, the Rankin County Sheriff remains tied
7
to a
months
civil
ago.
rights lawsuit that's been filed by 2 men abused at the hands of a group of deputies known as the Goon Squad. The news came today after a federal judge refused to dismiss Sheriff Brian Bailey from the case. 16 WAPT's Kendall Jones has more on the lawsuit that is worth $400 million.
Judge Daniel P. Jordan III denied a request from Rankin County Sheriff Brian Bailey to dismiss him from a $400 million lawsuit filed by the 2 victims, Michael Jenkins and Eddie Parker, who were tortured by the Goon Squad. The acts all occurring in January on New Year's Day. Jenkins and Parker were beaten, humiliated, and Jenkins was shot in the mouth at a home in Braxton by 5 former Rankin County deputies and 1 former Richland police officer who tried to cover up the ordeal. All 6 pled guilty to state and federal charges and were sentenced to between 15 and 45 years in prison. In the lawsuit, attorneys for Jenkins and Parker argued that Bailey failed to supervise, train, and discipline the deputies. Bailey asked U.S. District Judge Daniel P. Jordan III to dismiss him from the lawsuit, claiming he had qualified immunity, which protects law enforcement officers from accountability.
They said it protects them from accountability, not what qualified immunity was supposed to be for. Qualified immunity was supposed to protect them in the event they did everything correct. They crossed their T's and they dotted their I's. Everything correct. They broke no laws. They did everything correct. Then you can't come back and sue them for some bullshit. That's what qualified immunity, but they said it right there, protect them from accountability.
If they're accused of violating citizens' rights. In Judge Jordan's ruling, he says while Bailey was not present when Jenkins and Parker were assaulted, the plaintiffs can still file a claim against the sheriff by showing that his conduct deprived them of their rights. Trent Walker, an attorney representing Jenkins and Parker, said they are pleased with the ruling, saying it was in line with their expectations. A spokesperson with Sheriff Bailey says he has no comment.
That was 16 WAPT's Kendall Jones reporting. Several organizations have called for Sheriff Bailey to resign. The sheriff has previously said that he will not step down.
Alrighty, so this is from 7 months ago. I'm going to keep a watch on this one and see where this goes. Please don't prosecute me. I want a little bit of that qualified immunity. Please fucking stop. They all need to be in prison. So yeah, this is where we're at with this one. Let me know what you think about it in the comments. Like, share, subscribe. Also, again, here we go. Some harassment time. 93% of people that watch these videos are not subscribed to the channel. You're at your computer. You have your phone literally in your hand right this minute. All you got to do is hit the button and I'll quit harassing you. Let me know what you think about this one and I'm out.